Mr. Taylor's going to be pleading guilty to DUI first offense, received the mandatory minimum penalties. He has already served the required jail time, be placed on probation, required to pay the fine, driver's license revoked for a year. I've also passed up the notice of enhanced punishment. I've provided him with a copy. We've reviewed that, given waiver reading.
All right. Mr. Taylor, raise your right hand. Let's place you under oath.
Do you solemnly swear affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can put your hand down now. State your full name for the record.
Nathaniel Ryan Taylor.
Step up there a little closer. You won't have to bend over. It'll just pick you up and see you.
Nathaniel Ryan Taylor.
Mr. Taylor, you're here today charged with driving under the influence of first offense. Do you understand what you're charged with? Have you seen or been shown a copy of the charges? And you and Mr. Clemens talk about the range of punishment you're facing and any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of no contest. Do you understand that means you're not going to admit you did anything wrong, but you're not going to contest the state's evidence, and their evidence is what I'm going to use to find you guilty according to this agreement. You understand that?
Yes, sir.
Do you understand you have the right to plead not guilty and have a speedy and public trial by jury in this court? You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed, as we've done with the public defender. I need you to speak up just a little bit because we're recording everything. You don't have to bend over, but just talk a little louder.
Yes, sir.
So, you understand that if you went to trial, you'd be presumed to be innocent until such time as ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted.
Yes, sir.
You understand that at trial, you and Mr. Clemens could confront and cross-examine all the witnesses the state called to testify, and you could bring in your own witnesses by use of a subpoena.
Sir.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction on the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Sir.
You understand that by entering this plea of no contest, you're waiving your right to the trial and to the appeal. All I'm going to do is approve what your lawyers worked out.
Yes, sir.
You understand that's going to result in a conviction, and that conviction is going to be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes, sir.
As Mr. Clemens stated, I've been handed a document called the Notice of DUI Punishment that can set forth all of the enhancement provisions of the law. In other words, every conviction carries with it the next one being more severe.
Yes, sir.
Did you go over that, and do you understand all of those terms? Do you have any questions about it?
Yes, sir.
All right. Do you understand everything that I've explained so far?
Yes, sir.
You want to plead no contest according to this agreement and waive your right to a trial?
Yes.
You don't want a trial, you want
Yeah.
to take this plea, okay.
You know.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
No, sir.
You understand I can't accept your plea unless I'm satisfied there's a factual basis for it and that you are in fact guilty. In other words, I have to have facts to support your finding you guilty. Since you're not admitting anything, somebody's got to tell me what you did for me to find you guilty. You understand that?
Yes.
All right, so just listen as the state steps up to the microphone or uses the microphone on the desk there to tell me what their evidence would be at trial.
Your Honor, if we had taken this to trial, the state would have put on proof that on March 28th of 2024, the defendant was observed traveling on Highway 20 here in Stewart County by then Deputy Park, the Sheriff's Office. He recognized the driver, Your Honor, and knew that he didn't have a valid driver's license, so he conducted a traffic stop. And he made contact with the defendant. The defendant said, I shouldn't be on the road, and the deputy noticed an odor of alcohol, performed field sobriety tests. The defendant performed poorly on those field sobriety tests, such that the deputy thought he was under the influence, arrested him for DUI, and the defendant admitted to having 3 assaults.
I'm not asking you to agree with those facts, but do you understand that's what the state's evidence would be if this case went to trial? You still wish to plead no contest? You still want to take this deal?
Yes.
Are you satisfied with Mr. Clemens' service?
Yes.
You think he's done a good job representing your company? All right. Mr. Clemens, you know of any reason he should not enter this plea?
No, Your Honor.
All right. Then upon your plea of no contest, Mr. Taylor, I find you guilty, or that you be sentenced to 11 months and 29 days in county jail and will be suspended after you serve
It's okay.
That will be suspended after you serve 48 hours. You're going to be on probation, but you're going to have 48 hours in jail, but you're getting credit for the time that you've already served, which is more than 48 hours. You're going to pay a $350 fine at court costs, and your loss of driver's license will be for 1 year. You must complete the DUI school of the victim impact county. So, all right, thank you. Mr. Clemens, when I was practicing, I had a case in another county in which my client was charged with DUI, and they had a videotape of him when we were watching it with the DA get ready for the trial, and they were trying to get him to perform his field sobriety test. He said, "I can't do that. I'm drunk." But needless to say, we didn't have much of a defense after that. So.
Understood, Your Honor.
Right. 2023 CR 103 State versus Billy Russell Tomlinson. It's also your case, Mr. Clemens.
Yes, Your Honor. Mr. Tomlinson, come on up, please. He had been locked up in another county on some unrelated matters when this case got started. He and I think, are meeting in person for the first time today. He had called me when he got out of jail in the other county. This has been set for status. I'd like to set this for another status.
Right, August the 10th.
August the 10th.
Right. State versus Crystal Romero Quintana. That was the expungement, correct?
Oh, yeah, we took care of that before, Your Honor.
Well, State versus Dylan Estes.
Your Honor, that's my case. Thought Miss Caroline Black was going to have some pre-trial motions set today, but she's going to set them on the 22nd.
All right. We're going to set them on the 22nd.
Yes, Your Honor, that's the day before trial.
Yeah, it's the Houston County case, not Stewart.
Gotcha. That's cool. All right. And we have one add-on case, which is Bay versus Barry D. Gray. More.
Judge, Mr. Gray had his two cases. One of the cases made requested. He's got a motion in there.
A defendant appeared in court on a DUI charge and chose to enter a no contest plea rather than fight the case at trial. Prosecutors then revealed the evidence, including the traffic stop and signs of intoxication observed by law enforcement. After reviewing the facts, the judge accepted the plea and found the defendant guilty. He received the mandatory DUI penalties, including probation, fines, and a suspended license. Just when the hearing seemed over, the judge shared a funny story from his legal career that brought laughter to the courtroom.
Gray, raise your right hand.
You solemnly swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you.
I'm going to have you've got a motion for me to waive your remaining fines of $1,500 roughly dollars. Before I can do that, I'm going to need to see what kind of economic situation you've got. So I'm going to have you fill out an affidavit of your income and expenses for me to see whether or not there's any basis for me to relieve you of that obligation.
All right.
You fill that out and I'll come back to you, okay?
Thanks.
See, yeah, wait just a second. Mr. Nixon is up here now.
Mr. Nixon is represented by Mr. Stanford. Have you heard from Mr. Stanford today?
No, Your Honor.
Possible not, maybe his assistant attached now usually doing so. I said that if they'd have to take it up with you, so especially working she was here this morning, his assistant. Hadn't heard.
She's out. Oh,
Hmm.
she's out.
Is Mr. Stanford's assistant?
Yes.
Let's have her come in. We're looking for Dennis Stanford.
Yes, sir. He had car trouble and was not able to get here today. We're trying to find another attorney who's willing to argue his motion unless he can go by Zoom or WebEx. Or we can push it to another,
Or what?
or we can push it to another day or next month. If that is okay.
Well, first of all, you're saying Mr. Stanford can't make it here at all today, correct?
Yes. Unless you have another availability during this week.
Well, we have a trial that was supposed to go tomorrow, but it has now been settled. I'm sorry, been continued. Is that the only thing that was set tomorrow, Joe?
I'm sorry, Paul Davidson? Yes, sir.
Tomorrow.
Sir, yeah,
Paul Davidson case was set for tomorrow. It got continued. Is that the only thing that was set? Who's arguing this motion with Mr.? This is Mr. Nixon.
I know I've spoken with her. The state's in that objection, parallel with Mr. Nixon. So,
I can do, I'll probably get it for yours.
okay.
I can do it, Your Honor.
Well, Mr. Nixon, your lawyers filed a motion asking for you to be furloughed to go have an evaluation done. And have you evaluated and treated? I've dealt with you a long time. Do you have any problem with being furloughed to a treatment center?
Judge Wolfe, I asked for that last time I was in here. I asked for it when I got sentenced last time.
State does not. That's all right. Mr. Nixon and I know each other well.
Very
So
well, thank you, Judge.
I will approve the motion for.
State does object.
Oh, they do object. I'm sorry. I thought you said you voted.
We object to any kind of furlough in this case. No.
All right. Well, then we'll need to set it for a hearing. Can you do this tomorrow?
I can do it, Your Honor.
What about Mr. Stanford? Do you know who
I can
he's?
make sure that he's available, sir.
Pardon?
I can make sure that he's available.
Okay. Well, let's. Before we leave today, I'm going to take a recess to review this other information here that I've got to deal with, and we'll come back to Mr. Nixon's case. Is there anybody else who has a matter that we've not dealt with? We're waiting on a couple of lawyers.
Just Mr. Singletary. Mr. Singletary, thank you. You don't say.
William Singletary. Singletary, I had you placed under oath, but this information that you've supplied about your total income, is that true and correct? You're on disability, is that correct? All right. I find Mr. Singletary to be indigent, therefore I'll appoint the public defender. We already give you, I think I gave you your copy of that affidavit, so you might want to share that with your lawyer.
Your Honor, on behalf of Mr. Singletary, has already been given a copy of that.
It's an affidavit of violation of probation. You want to have it set for next month then?
Yes, Your Honor, please.
What is the date in May?
5/11.
May the 11th.
I give that to her. Yes, Judge.
All right, I'm going to take a recess to review the information that the members have provided, as well as some other information. We'll come back to you. All rise. Have a seat. All right, let's move. Robert Kaiser, Ms. York, are you ready on that?
Yes, Your Honor. Yeah, that's- Yes. Go ahead.
I had filed a motion to withdraw or in the alternative continue this case. Mr. Kaiser is adamant there is missing body cam footage. So I was going to request continuance to investigate that. Aside from that, he just really hasn't been listening to my advice or really having much to do with anything that I have to say.
The courtroom took another unexpected turn when a defendant asked the judge to waive nearly $1,500 in fines, while another sought permission to leave custody for treatment. As lawyers debated missing evidence and body camera footage, tensions began to rise. One defendant insisted critical video evidence was missing, while his attorney admitted there was no proof it actually existed. What started as a routine hearing quickly turned into a dispute over evidence, legal strategy, and courtroom trust.
You have a motion to suppress down today, correct? And your motion to withdraw is based on the fact that there's supposedly some missing body cam footage?
Yes, that's correct.
What evidence do you have to believe that there is actually any missing evidence?
I've talked to Mr. Woodall. I personally don't have any reasonable belief there would be, but I followed it just out of abundance of caution.
Can I say something?
Yes, sir.
Mr. Chad Cox got it. And I've notified him ever since I've been in. He's talking about his office is getting renovated. He don't have time to find it. Because he was my attorney. I had, in my discovery, it was one fiber out, whatever you plug into those to look at your discovery. He had one. She has four. And the one she had, Mr. Cox didn't have, because I think it was extra to it. It was a lot more to it than what's been asked. So I asked her to get what she has sent up to the lab, to the TBI to make sure, because I know it's been tampered with. Because that ain't what I'm seeing. I know what he showed. But since he stepped down, now his office is in renovation. He didn't send it. And the things that I read is like he shouldn't even done nothing with it until 2 years or a few years after my case is closed. So why is now all of a sudden it's gone? And he keeps sending different stuff. My discovery pack was filed with Runyon. But since
How many
then,
different lawyers have you had?
Runyon, he stepped down because he's a friend of the sheriff's, which had nothing to do with this case, but the courts allowed him to do that. She's a relative to the police that's on my case. So really, I can't be truthful to her.
On this case, Jay Muller, Stewart County Sheriff's Office?
No, on the ones that's also set for
We're
today.
not worried about that
The
one.
ones that's set for today.
The one that's set for today is the motion that the case that's set for Thursday, is it Thursday?
Yes, Your Honor, it's Thursday.
Set for Thursday for trial, and those charges are possession of a firearm by a felon, revoked license, first offense, the unlawful drug paraphernalia, and seatbelt violation. That's the only case that is set for Thursday.
But I was told I had cases set today, and it's not the one she filed. It was for a four-wheeler and a Class E felony, a class for evading arrest. That was also set for today.
That's set for status apparently, but it's not
Right.
set for trial.
Yes, I can't be truthful to her when it's just a conflict. I mean, I've asked her to file those motions. Every time I ask her to file something, she says she's got to ask the DA or go to the DA. The DA's not working with me. I'm working with her. So even her uncle told my wife that the DA is going to prosecute me. So how does her uncle know? Let's just get it talked about around the kitchen table. I cannot trust that. So I've spoken to two attorneys that I was going to hire, but I'm in jail, so I can't hire. But like again, she's handled a lot of stuff of mine. But when I ask her to file something, it's always, but the DA said this, the DA done that. But what about the evidence that we supposed to be collecting? She hadn't investigated where I was pulled over at, the why I was pulled over, the body. It's a lot to it. It's a lot to it, and I can't even address nothing with her because it's not confidential. It goes from her mouth to her uncle's mouth to the DA's mouth, and I can't do that. That's why I don't talk to her. She told me the first time I talked to her, I know her dad. So I said, how? She won't tell me.
I have not disclosed any information regarding this case to anyone, so.
Well, I was made aware of the obligation or the argument that you had to make about her situation. I'm not so sure that, my first inclination was that I was not going to grant her motion to withdraw and I wasn't going to continue your case because it's been pending since 2021.
Yes, sir.
And she is the third or fourth lawyer that you've had appointed, and we keep appointing lawyers, and then there's some issue. Be quiet when I'm talking.
Yes, sir.
That there are several times that that's has to happen. My concern now, generally, despite what we have discussed in the chambers, is that Ms. York is being placed in a situation where she's likely to not have a good way out of it. If she continues in the case because I don't grant her motion to withdraw, then it seems to me that that will create an issue for post-conviction relief that otherwise would not be present if she is allowed to withdraw, and that resolves the issue about supposedly the lack of discovery, although I'm of the opinion that this is a pretty straightforward case. I mean, it's a case of driving on a revoked license and in possession of a handgun. So I don't know how the evidence could be that, but the state is objecting to a continuance and a motion to withdraw.
That's correct, Your Honor. State's, it's the state's opinion. This is Mr. Kaiser's another attempt, Mr. Kaiser, just to delay this case. We've been going down the road. State's been ready since Mr. Runnion's had this case. The state's been ready since Mr. Cox had this case. The state's ready for trial Thursday. I understand your ruling.
Clemens, what conflict does your office have with this individual?
I don't recall the exact conflict. I think it might have been that there was a PCR filed against our office. Mr. Kaiser?
That's been 25 years ago.
Your Honor, I'm happy to be standing in if you needed to appoint a counsel, and I could probably go forward with trial on Thursday as well if I can get the discovery today.
And you're Mr. White?
Yes, Your Honor.
Well, I'm going to allow Ms. York to withdraw on her motion based on the fact that she has divulged that there is some relation between her, someone in her family distantly has some relation to another case that this defendant has, and I'm of the opinion that it's puts her in a position where the appearance of impropriety could attach. So we're going to protect Ms. York from having that issue raised by allowing her to withdraw, and I'll appoint Mr. Kendall White. Now, Mr. White, you can talk in general.
I'll be glad to talk.
We'll all about it and see if you can be ready for trial before I leave today. I just need to know if we're going through with the trial on Thursday. So,
Yes, Your Honor.
The courtroom suddenly became tense when a defendant accused his own attorney of having a conflict of interest and claimed important evidence was missing. He argued that he could no longer trust his lawyer, while prosecutors insisted it was just another attempt to delay the case. After hearing both sides, the judge faced a difficult decision. In the end, he allowed the attorney to withdraw and appointed new counsel, setting the stage for another dramatic courtroom battle.